say this is the board formerly known as duly appointed. It's not in the public interest to award or encourage erratic behavior of an about to be ousted board, especially with this board's history and that they are on, they won't be around for long. This is the board that gave Mr. Elzey a satisfactory performance evaluation and then told him to clean out his office, and while he was still under contract, named his replacement. This is a board that refused to adopt his comprehensive financial plan in January, and then after they put him on leave, they voted to approve and adopt it in its entirety. This is a board that entered into a written agreement with Mr. Elzey last August to improve their communications with him and to tell them what their expectations were. And then 6 months later, they put in writing in a letter what the expectations were after they had already put him on leave. And their expectations were that they wanted to hire and fire the employees at South Carolina State University. We're likely to prevail on the merits of this case because there is no cause to terminate Mr. Elzey or to have an acting president in his office as we speak today. And worse, the board has documented consistently since they put him on leave that there is no cause. The letter putting him on leave states no reason. A subsequent February 25th letter states the reasons for the board's actions are that it's in the university's best interest, whatever that means, but it certainly has nothing to do with whether or not there's cause to terminate the contract, which is the only reason to terminate the contract. A recent vote of no confidence is nothing similar to the concept of cause to terminate an employment contract. In the employment arena, the concept of terminating an employee for cause is strictly limited, though the university did not define cause in this contract when they had the opportunity to. Many states have statutes on that issue, and in South Carolina we don't, but it is assumed that if an employee is terminated for cause, it's something very serious. It's fraud, it's criminal activity, it's theft. And of course, nothing like that has happened or is alleged in this case. In fact, the board has spent the last 3 weeks documenting that there is no cause to terminate Mr. Elzey's contract, and therefore it's very likely we will succeed on the merits of the case for the breach of contract. Mr. Elzey is going to suffer irreparable harm if the stay is vacated and a preliminary injunction is not granted. That's because he did an excellent job as a financial director of the Citadel. He's well respected and admired. And this is his first time that he's been the president of a university. If he is ousted for cause, as this board has said they intend to do, monetary damages will not be sufficient. His career is dead-ended. The doors have closed, and he will never be able again to be the president of a university. No amount of money can remedy that loss. And to sidetrack his whole career and take him out of an area of employment that he wants to do is irreparable.
I would acknowledge that this case may be complicated politically, but happily it's not complicated legally, because the only legal issue is whether the stay or the temporary restraining order that the court issued last week should remain in effect. And I'll start by acknowledging that South Carolina State University has some very serious problems, and all the members of the board acknowledge and recognize that. But I think it's important to point out that the board did not create these problems, they inherited them. And I want for the record to say that there are 10 current board members, 9 of them were appointed by the legislature, 1 was appointed by the governor. And the current board includes 2 attorneys, 2 college professors, a minister, several professional educators, and a distinguished banker. And there's no question, I think the court has already pointed out, that the current board that I've just characterized and described is clearly in charge of the university. Now, one of the things that my worthy opponent did not include in her argument is that the contract that the current board has, and I don't know the exact number, but the majority of the current board did not enter into that contract, but they are obviously bound by it. That contract provides that the board has the right to unilaterally terminate the contract. And the contract is before the court. It's part of the record submitted by the plaintiff. In the first paragraph of the contract, it says that if they don't discharge for cause, which means they have the right to discharge for cause, they clearly have the right to discharge for any reason or no reason by paying a specific sum of money, the state portion of the contract. Now, obviously, the contract provides that it can be terminated for cause. They would have to follow due process procedures to do that, and the current board is committed to following the law, whatever course of action they may take. Now, the legal issue, as I pointed out, which is black letter law, we are all familiar with it. If you have damages, you don't have irreparable harm. You can recover damages, and of course, Mrs. Bloodgood has outlined damage claims that she thinks that she has, but the other side of that, of course, is if you have damage claims, you don't have irreparable harm. Also, we clearly have here the second requirement for an injunction. There's no adequate remedy at law. Well, if you have damages, and she has asserted that they do or will have damage claims, they certainly have an adequate remedy of law. And the most important point, as far as the President's contract is concerned, is that the current board has taken no action on the current contract. They have simply placed the President on administrative leave, and they have appointed an acting President for the temporary situation. So the bottom line here is that legally, we don't think there is any basis for continuing the injunction or the stay. That's the essence of our position.